Good morning. I would now
Recording in progress.
let me try that again. Good morning. I would now like to call to order today's meeting of August 8th, 2023. Roll call, please.
Vice Chair Gallagher,
Here.
Supervisor Cottrell,
Here.
Supervisor Pedrosa, Supervisor Gregory,
Here.
Chair Ramos.
Here. And at this time, I will add a little 1A on our agenda, and I would like to take this moment to introduce Napa County's CEO, Brian Alsop, who joined us yesterday, and he will lead us in the pledge. Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Next on our agenda, we have two sets of minutes for approval. Any comments or corrections by the board? Seeing none, I'll ask for public comment on the minutes. I see no public comment in the boardroom. Do we have any on the line for minutes?
No one on the phone.
I'll close public comment. I'll bring it back to the board for decision.
Move approval. Second.
We have a motion by Supervisor Pedrosa, second by Supervisor Gregory. All those in favor?
Aye.
Opposed? Motion passes unanimously. This morning, we do not have any presentations or commendations. Is that correct, Mr. CEO? Excellent. Department head reports or announcements? Do not have any. We will move on to our consent items for special districts. Item 6A, one matter for our consideration. Are there any questions from the board? Seeing none, I'll go to public comment. Public comment in the room. I see none. Do we have any on the phone lines for 6A? Seeing none, I'll close public comment. I'll bring it back to the board for decision.
So moved.
We have a motion by Supervisor Cottrell, second by Supervisor Pedrosa. All those in favor?
Aye.
Aye.
Opposed? Motion passes unanimously. Next, we'll move on to our consent items, and we have two correction memos under our agenda, item 7U and 7W. Is that correct, Madam Clerk? Did I
Yes,
get
Chair.
that?
Thank you.
Excellent. Okay. Any items to be pulled by the board or any questions? Seeing none, I will open public comment on the consent calendar. See none in the boardroom. Any on the phone lines?
No one on the line.
Thank you. I'll bring it back to the board. This is for your consideration. All items under item 7, including the correction memos of U and W.
So moved.
Second.
We have a motion by the G's, Supervisor Gallagher and Supervisor Gregory. All those in favor?
Aye.
Aye. Opposed? Motion passes unanimously. We did not have any items pulled on our consent calendar. Next, I'll open public comment. This is for public comment on matters not listed on the agenda but within the jurisdiction of the Board of Supervisors and the special districts, and public comment is limited to 3 minutes.
Good morning, James Hinton, 3574 Hunter Circle, Napa, California. Just under 1 year ago today, on August 10th, 2022, my day started off at the voter registration office, and I ended up at Queen of the Valley Hospital. I was savagely beaten. I had got sucker punched in the back of the head. I was beaten. I got my ribs broke, black eye. I was hitting the kidney that hurt a lot. I got up. I ran for my life. The police arrested him. The district attorney charged him with felony assault with injury. And an unelected judge named Francisca Tischer basically threw the whole case out of court and gave the guy 10 days coaching football at Napa High as a punishment. And he had already been arrested 3 times that year for beating his estranged wife. And then he came over and did a good number on me. And that's why I don't stand up for the Pledge of Allegiance. We don't have justice. Justice is a myth. Justice is only for the rich people. And it's a sad, sad world we live in when you go and you wonder why we have so much domestic violence in our community. It's because these people, they don't testify, they remain silent, They get these public defenders or other attorneys that just lie right through their teeth, and these judges are susceptible to believe in this stuff. And there's really, when you have Francisca Tischer, who's a retired judge, you can't recall her. All you can do is complain about her. That's about it. And she's sitting here with all this power. And she was reprimanded over 20 years ago by the state for ruling in favor of somebody with the same last name as the person that attacked me. And, you know, I'm really grateful that our district attorney did her job and that her staff did their job. But seeing how, you know, we don't even go to a jury trial because she wants to say, well, Allison Haley, this isn't a felony. This should be a misdemeanor. And then the guy says, well, I don't want to go to trial. I want diversions or whatever. Okay, you want to coach football for 10 days? She thought 15 days of coaching football was too much, so she reduced it to 10. But that's the world we live in. There is no justice. And I just want to remind everybody, for the last 6 weeks, I've been trying to get information about our tax money going to visit Napa Valley. And there's not one politician in this room, there's not one politician on the city council that is following the money. Visit Napa Valley is completely unaccountable. They will not show us where their tax dollars are being spent. And it's ridiculous. I don't know why we just don't get rid of it and disband it. If they're not going to follow the rules and they're not going to tell you what they're doing, why are we still handing the money over and looking the other way? That's $10 million a year. We could raise our TOT and give it to our community instead.
Thank you. Next public comment. Seeing none in the boardroom, I'll turn over to the phone lines.
There's no one on the chair. However, can I make a quick announcement? We're having some issues on our network servers that is not allowing access on our website. So if you are watching and you need access, please use Zoom or YouTube. We have available options there for you to view, and our website seems to be working. So we have intermittent outages on our website, but Zoom and YouTube are fully functioning.
Thank you. Seeing as there's no other public comment, I'll close public comment and I'll move on. We do not have any administrative items for our special districts. Our first item this morning for our consideration, item 11A, County Council requests the Board of Supervisors receive an update on FPPC regulations implementing Senate Bill 1439's amendments to the Political Reform Act. And with us is our Deputy County Counsel, Mr. Fitzgerald, to present. Good morning.
Okay. Is that right? Okay. I believe there should be some slides. There we go. Okay. So I've been asked to present on some updates to the FPPC regulations. As you know, effective January 1st, part of the Political Reform Act found in Government Code Section 84308 was amended, and last month the Fair Political Practices Commission adopted regulations interpreting that amendment. These regulations are effective beginning this coming Saturday, and they're the focus of this presentation. So to start with a little bit of history, in the early 80s, the LA Times reported about scandal involving coastal commissioners soliciting campaign contributions from people with applications pending before them. So in response, the legislature passed AB 1040 in 1982, which barred appointed members of boards and commissions from accepting, soliciting, or directing contributions of $250 or more from any party participant or agent of a party or participant while a proceeding involving a license, permit, or other entitlement for use was pending before the agency and for 3 months following the final decision. The intent was to curb pay-to-play schemes and reassure the public that appointed members of boards and commissions were not influenced by campaign contributions and that officials were not using their positions of authority to unduly influence applicants to make contributions to their campaigns. So locally, this would have applied to our planning commission, but not to the Board of Supervisors. Then, you got me? Thank you. Then last year, SB 1439 was signed into law and became effective on January 1st of 2023. This part of the government code was extended to apply not only to appointed members of boards and commissions, but to local elected officials as well. The amendment also increased the back-end barrier to receipt of contributions from 3 months to 12 months following the final decision date. According to the bill's author, this was designed to close loopholes that allowed directly elected politicians to act on matters that affected their contributors. So if an elected official or a contributor violates the amended code, they're subject to enforcement as provided under the Political Reform Act, namely administrative enforcement and potential criminal and civil penalties. And unlike instances where officials themselves have a financial interest in a contract entered with the county or a personal conflict of interest, there is no provision in the government code for voiding the contracts or voiding any contracts that have a government code 84308 violation. So the penalties are personal rather than to the county. So this is a restatement of the government code as it presently reads. While a proceeding is pending and for 12 months after the decision, an officer may not accept, solicit, or direct a contribution of 250 plus from a party participant or their agents. Parties, participants, and agents are likewise prohibited from contributing 250 plus while a matter is pending and for 12 months post-decision. An officer who received 250 plus from a party participant or agent in the 12 months prior to the proceeding before the agency must disclose this on the record and recuse themselves. Parties and their agents are also required to disclose such contributions on the record. Contributions made more than 12 months before the proceeding are not covered by the amended code. And officers do have opportunities to cure would-be violations with prompt returns of contributions, and then they may lawfully participate. So if you accept a donation within 12 months before a proceeding, but before it's pending, you may have the option to return the contribution and participate, but you aren't required to return the contribution if it's before the matter is pending. But if you don't return it, you would be barred from participation. So the focus of this presentation is on the role of officers, but note that parties and participants are also prohibited from making contributions during certain windows, and they're also subject to disclosure requirements and potential penalties under the Political Reform Act. Okay, so affected parties have raised a lot of questions about the practical effects of the amended code section. For example, are contributions prior to the January 1st, 2023 effective date covered by the amended code? Restrictions are said to apply to a party or participant in a proceeding that is, quote, before the agency. Does this encompass the entire county? For the purposes of accepting, soliciting, or directing contributions, when is a matter regarded as pending? We'll see that there's two different standards for parties as opposed to officials. What conditions lead to an elected official being disqualified from participating in a proceeding? Does an elected official have a duty to determine the financial interests of individuals appearing before them? What must an elected official do upon determining that there is a disqualifying financial interest? And the new FPPC regulations are designed to address these questions, and again, they go into effect this Saturday. So before getting into the questions, I want to touch on a couple definitions and key concepts. So party is pretty self-explanatory, but you also need to keep an eye out for participants. And participants are those people who have both a financial interest in the outcome of a decision that aren't a party, and they act to influence officers of the agency by lobbying, testifying, or otherwise acting to influence officers. Notably, the regulations exclude communications made to the public except in proceedings before the agency. That means that somebody can do a radio interview, publish a letter to the editor, or participate in a rally outside the government facility here, and they wouldn't be a participant unless they also communicate directly with an official. Agents are treated like their principals under the amended government code, but to be an agent, one must be compensated, so volunteers are not agents under the regulations. And the 250 contribution limit is the sum of a party or participant's contributions, their agent's contributions, and contributions of any individual or entity required to be aggregated. So for example, if we have a party that's a business, the business's principals would be aggregated. If we have a party who is an individual, if they have a controlling stake in a business, the business's contributions would also be aggregated. So turning to the questions, good news is the FPPC issued an opinion in December 2022 and has confirmed in regulations that the government code amendment only applies to proceedings and contributions from from January 1st, 2023 onward. So this avoids difficult situations where a contribution would have been lawfully solicited and received last year, and now it would be too late for an official to return that contribution. So that's good. And then as to the scope of the agency, the regulations clarify that agency should not be read so broadly as to mean the whole county. In the FPPC's staff memo to the commission, they provided the following example. A person with a matter pending before the Planning Commission could not contribute to a planning commissioner, but they could donate to a member of the library board, and the library board member would be allowed to accept. The library board is not the same agency for these purposes because the board members have no influence or control over the Planning Commission's proceedings. Okay, so regulations also address the time period when an officer is barred from accepting, soliciting, or directing contributions. So generally, an officer, for an officer, a matter is pending once it has been agendized or once the officer knows or has reason to know of it. It is a violation to accept, solicit, or direct a contribution during that period. But note there is a different standard for donors. For a donor, a matter is pending as soon as they take an action which makes the matter pending. So the example is given by the FPPC. A county supervisor would have no reason to know about a permit application submitted to the building department, but the applicant does, and so from the date that they submit their permit application on, the matter is pending as it relates to the applicant. But for a member of the Board of Supervisors, it's not pending until it's agendized or until other facts are revealed to them, which make them aware of it. Another example provided was that an entity seeking a waste management contract has a matter that's pending upon submission of a proposal to Public Works, and it would be a violation for them to then make a contribution to a city council member, even if the city council will not award the contract for 12 or more months. So in both of these examples, the act of making a contribution would constitute a violation by the donor, while the act of receiving by the elected official would not be, based on the two different pending standards. So turning to the question of what conditions disqualify an official from participating in a proceeding, this slide addresses which proceedings are not covered. So generally, you should expect that most proceedings would be covered, but ministerial decisions, those that involve little or no personal judgment, competitively bid contracts that are required to be awarded to the lowest responsible bidder, and labor contracts, including those reached through collective bargaining, and personal employment contracts between the agency and employer are not covered as proceedings, but generally other proceedings are found to be within the scope of the amended government code section. Okay, so continuing with the question of the contributions which disqualify elected officials from participating in proceedings, this slide addresses two factors with knowledge components. An officer must recuse if they willfully or knowingly received a contribution from a party, participant, or their agent within the previous 12 months, and for contributions from participants, the officer must also have reason to know that the participant has a financial interest. Willful or knowing acceptance of a contribution is triggered by facts which should prompt the officer to investigate whether the party, participant, or their agent has contributed to them. An officer is deemed to have willfully or knowingly received a contribution if they have actual knowledge, if the contribution has been disclosed by the party or participant at the proceeding, if the officer is aware of facts establishing other reasons to know of the contribution, including, according to the regs, the officer has been informed of the contribution, the party or participant has made 2 or more contributions of $250 plus to the officer in the past, the officer personally solicited the party or participant, the officer personally accepted a contribution from the party or participant, and then the officer has reason to know of a participant's financial interest if there's actual knowledge, if the participant reveals facts during the proceeding that make their interest apparent. An officer is deemed aware if the participant reveals an interest in real property within 500 feet of the property at issue, an economic interest in a business entity which may see significant increase or decrease in customers as a result of the proceeding, or business relationship with the applicant that may result in additional services provided to the participant. If there is a financial interest, but by a clear and convincing evidence standard, it's an immaterial financial interest, then there's no disqualification trigger. But we haven't seen any test cases of what that looks like. The code and the regs do not obligate. So the good news is the code and the regs don't obligate officials to dig in and do an actual full inquiry into the financial interests of the individuals appearing before them. So that was answered explicitly by the FPPC in a fact sheet published earlier this year. Okay, so thank you for bearing with me and sticking with me here. Officials have duties where disqualifying conditions exist. So the regulations don't require the officer to disclose the dollar amount received by a party or participant. The requirement is just that they need to disclose the fact that they've received an aggregated contribution in the preceding 12 months in an amount of more than $250 from a party or participant. So you don't need to identify the party or participant or specify the amount in the disclosure. Just the fact of the disqualifying contribution is sufficient. And this must be done prior to participating in the proceeding, but it doesn't mean that it needs to be in the form of a verbal announcement. So for example, if it's known ahead of the proceeding that an official is barred from participating, that fact may be written in the agenda, or it can be announced by staff in the official's absence. So it doesn't need to be that the official is making a statement about it. It can be in the record without them announcing it. But if facts are revealed during the proceeding that cause the individual or cause the official to realize that the participant was a donor within the last 12 months and that they have a financial interest, the official must disclose this immediately. All right, so officials have opportunities to cure violations or would-be violations. So where an officer has received a contribution from a party before they knew or had reason to know of the proceeding involving the party, or where they received a contribution from a participant before they knew of the participant's financial interest, an official may return the contribution or any part of the contribution that exceeded $250 within 30 days of learning about the contribution in the proceeding. So the official's not required to do this to avoid a violation, but if they don't return funds within the specified time, it would be a violation if they failed to disclose and recuse. And so for another option to cure, say for example, a speaker at a proceeding who you know is one of your donors reveals facts previously unknown to you that show that they have a financial interest in the outcome of the proceeding, you must immediately disclose the disqualifying contribution on the record and state that it will be returned within 30 days. You may then continue to participate, but if you fail to actually return the contribution within the specified time, that would be a violation. And note, as previously discussed, immediate disclosure is required when such facts are revealed. However, you do not need to commit to returning the funds and may instead recuse and take no further part in the proceeding. After the proceeding has concluded, if you unknowingly accept, solicit, or direct a $250 contribution in the 12 months following that final decision, you may cure by returning the unlawful contribution within 14 days. This is only an option if it was, in fact, an unknowing acceptance. So if it was a knowing solicitation and acceptance, this is not an opportunity for you to cure. And so there are existing regulations on the books addressing situations where one or more officials have a conflict of interest, and there's no other way for the government to proceed. And these regulations have been extended to encompass the situations addressed by the recent amendments. So if you are looking like based on donations, you're not going to be able to reach a quorum, there are procedures in place for one disclosing and then drawing straws effectively to see what the quorum will consist of for that proceeding. So some policy recommendations. County Council recommends that the board consider several policies estimated to help protect parties, participants, and officials from inadvertently violating the Political Reform Act. We've observed other counties' agendas reminding members of the public of disclosure obligations in proceedings. RFP templates could also be updated to remind applicants that upon submission, they have a matter pending and contributions may be violations. Application and appeal forms circulated by the county could also bear such warnings. So we would be prepared to, at the board's direction, work with the CEO's office to take steps to implement those first 3 bullets, and then individual campaigns may also wish to take additional steps, including updating their questionnaires to prompt donors to identify any matters which may be pending before them. So the FPPC has indicated that they're going to be offering trainings and will be responsive to questions from the regulated community. This year, the FPPC has already issued 5 advice letters interpreting the amended government code. Most of that is focused on what constitutes a license, permit, or other entitlement for use. Most of those opinions are saying, yep, basically, if it's close, it's covered. And I'm not aware of any enforcement actions the FPPC has taken pursuant to the amended code. But as the code and the associated regulations get tested, the regulations may need to be revised again, and FPPC Commission staff acknowledged that. I've also, in the materials that are going to be posted online and that you already received, there's an appendix that outlines the hypothetical that FPPC Council devised and ran through with the Commission at their recent meeting. I think it's a helpful illustration of a lot of the concepts that I rushed through today. So it's not part of the presentation, but I think you may find it useful. And with that, I'd be glad to answer any questions and receive any direction from the board.
Thank you so much for this presentation. It's great that the FPPC finally got to some further clarifying points. And I'm going to, seeing as that we are here at, as defined in the agency part as one who has influence on decision and budgetary control, I'm going to set my questions there. When we look at appeal, and I'm looking at, for my benefit of my colleagues, on slide 9, appeal is pending. I'm thinking about a land use appeal coming from the Planning Commission.
Mm-hmm.
When that appeal has been filed, it has not yet been agendized.
Mm-hmm.
What is that? Where's that date determination?
For the official?
For the official.
So for the Planning Commission, it would be as soon as it's on the Planning Commission's agenda, then it would be pending, unless they have received other notice. If the applicant, made direct contact or something and said, hey, this is coming, keep an eye out for it or something, then it'd be pending based on actual knowledge. But for the Planning Commission, it would be pending as of the date that it's agendized, unless there are other facts. But for the applicant, it would be pending from the date that they submit that application. And for a secondary review, like if it were to be appealed or brought to this board, then it would be pending as of the date of agendization for this board, not based on the agendizing.
But not based on the appeal date? And I ask this because it takes us months, sometimes years, to get things to an actual agenda
Mm-hmm.
from the appeal date.
Mm-hmm.
So I think, just given how much we have appeals, I think some greater focus in that area of understanding the filing of the appeal to our agenda
Mm-hmm.
is a very long time sometimes.
If I may,
please.
Chair Ramos, for land use appeals, it's my understanding that we're required to schedule them within 90 days. And so we come to the board within 90 days, and typically we continue them. So when we're coming to the board, in that first 90 days, you would have notice. Potentially, you'd also have notice before that if the planning director sends you an email, and says, hey, here's an appeal. So arguably, you might have email notice in advance of when it actually gets on your agenda.
So perhaps our tentative appeal schedule or anticipated appeal schedule that we have coming from PBS might in fact be our constructive notice.
That's probably a good way to look at it, yes.
Okay. So I will say I think that there are a lot of opportunities for incorporation of that. Say and I'm looking back in the room to PBS when the tentative schedule comes out of anticipated items of what those dates are, because when we have them, they come to us as what the expected date of appeal and hearing would be, but it would be very helpful to know on also when those appeals were filed so that we have those date references as bookends. So that was one thing. My next one was, is there did the commission consider some sort of a expectation statement of sufficiency? Is there certain language? Is there a boilerplate, some sort of template for the recusal? The statement of recusal?
They didn't float any language. I'm sure that we can draft something
So
that
my
could be used.
recommendation for my colleagues' consideration would be that we already have predetermined language that either staff reads out or the individual officer can read out at the time of a hearing, so that there's consistency in that, and that it is clear and transparent as to what that recusal is about. Because if there's nothing that states what that sufficiency standard is, I'd be interested in that.
And that can appear in the agenda rather than being read out as well.
Yes,
yeah.
yes, but my recommendation would simply be that there be consistency among them. So then the other question that I have is, and this actually has happened to us, if you go from Planning Commission, appeal, up to us, the board, it gets appealed to the courts, and it comes back to us. Where is that point of our time, our 1 year time stops? Because we had this, we've had 2 certified questions back on land use matters on both Mountain Peak and on Hall. And so do we remain in that limbo state of wondering if it will come back to us because it remains in our jurisdiction if the Superior Court wants to punt it back?
Have those been returned within 12 months, or is that taking?
Yes.
Is it longer than? Okay.
Yes. 1 yes. My brain
Chair.
doesn't go that far.
I think that's an excellent question that we should run by the FPPC. I would think it's a little bit speculative that it's going to come back to us, but it's happened. So I think that may be worthy when we have our first situation where it goes off to court. We can pose that question.
I thank you. I think that would be a great item to just kind of keep and understand, because those were two appeals to the Superior Court back to back that came to us, and not to try and jinx us into saying that it would happen again, but certainly that 1 year somehow never seemed to stop. If these rules would have applied, that would have never stopped. Any other questions from the board? What? Oh. Buttons? Okay. No, you're first, Supervisor Cottrell. Go.
I can't yield the floor to Supervisor Gregory. Okay. Thank you very much for this presentation. It's really helpful. I think we've all been hearing that this was coming down the pike, and it's really nice to have the slides and the hard copy too. So first of all, I just want to circle back with the direction that you've asked for, and I think that's a great idea to ask County Council to provide some draft language for, that's on slide 18, those first three that you were discussing. And then on the fourth one there, you mentioned that that would be more on electeds and candidates to make sure they had the appropriate language in their campaign form. I think what I would ask is if you could come up with some sample language. That's obviously not something that you can prescribe, but I think having some examples would be really helpful.
Okay.
And then I just had a question about, you know, as we're going through what the definition of officer, agent, participant is, I was wondering if the 1439 committee looked at all at the issue of independent expenditures, where someone, you know, if I'm a participant in a proceeding, that means I'm going to be barred by this language from making a donation over $250 to someone who's going to be, you know, exercising judgment in that proceeding. But what happens if I make a donation to an independent expenditure committee or a PAC or something like that?
Those are both accepted.
Okay.
So those contributions are not aggregated as part of that.
Okay, so those sit outside this
Correct.
entire
Yeah, they're outside the
structure.
scope here.
Okay, thank you.
Supervisor Gregory.
Yes, thank you. I feel a lot more clear on this from the last time we talked about it. Appreciate your
Thank you.
research and your presentation. Just got a few clarifying questions. I think you addressed this, but I want to just ask again and have you reiterate it. If I receive a donation from someone in excess of $250, they become an applicant in 2 months. There's an issue with that. If I receive a donation of the same amount above $250 and they become an applicant 12 months or more beyond, that's a moot issue, right?
Yeah, that's not covered by the scope of
Correct.
the regs here and the
Got it.
code here.
So I think the question to any potential donors is, are you currently an applicant or are you planning to anytime in the near future?
That would be, yeah.
A-
That I think gets to the fourth bullet.
A fair question,
Yeah.
All right, and then party, participant, agent. So let's say that's a property owner, they're planner, and an architect and engineer. Those are examples of a party, participant, and agent.
So there's actually a carve out for architects and engineers if they're just submitting like plans and drawings that they would do in the course of their business in support of
Okay.
permit application. There's a special carve out for them.
Okay.
Yeah.
Okay.
If that, and I can send you that excerpt if you're
Please.
interested.
So it'd be property owner and let's say they're planning agent, 2 people. So we'd have to aggregate any donation from those 2.
Correct.
And it has to be below 250.
Correct.
If we want to avoid the
over
issue.
the course of 12 months, yes.
Okay, thanks. Just a couple more. I think of our very ministerial activities. I think of a building permit or lot line adjustment, versus a full-on entitlement. Is there a difference?
So ministerial decisions, those that don't require any real judgment on the part of the board, or like I think one of the primary examples was a contract that's awarded to a low bidder. Those aren't covered here. So to the extent that it is a ministerial decision, it's not covered by this amended section to the code.
Okay, thanks. And the last is, I don't know if you could put up slide 13, Ms. Hoskins. I'm not sure I'm clear on pending versus proceeding
Okay.
as it relates to us.
Mm-hmm.
And I think if we could look at slide 13, I think I can ask a better question. Thank you, perfect. So given how long we know things take, 12 months leading up to proceeding means they likely submitted a couple years ago, right?
Mm-hmm.
So if I took a contribution of 250 or more in those 12 months while they're an applicant, that doesn't seem allowable under
Right. If the matter is,
law.
if it's pending, and I think that kind of gets to what Cheryl was talking about a little bit about the long lead times and the announcements of tentative schedules and things of that nature. If it's pending, for the applicant or for the officer, then it's a violation to accept it, period. What the 12 months leading up to the proceeding is really, I think, anticipating is accept situations where you accept a donation and then later realize that that person or that donor has a matter that's going to come before you. But one of the examples that they gave in the staff report was this instance where you can have a matter pending for more than 12 months. So the pending can exceed 12 months. And then it's a violation to accept it. And it can't be, I mean, it can be cured if it's an accident and within 14 days, but you're limited in your ability to cure if it's pending.
Okay. It seems suggested in some of this that we may not know until we see it on an agenda.
Mm-hmm.
We just may not know they applied 2 years ago, even if we ask. So some of this suggests that if there's some remedy in that case,
Mm-hmm. Yes.
right?
Yes.
Okay.
There's some ability to cure.
Right. Okay. Thank you.
Supervisor Gallagher.
Thank you for the presentation. It does clarify things, but I think it also makes us realize that there's a lot of work to do to try to comply with this. So what if someone's an investor in a particular organization and but they don't have any knowledge of when that organization might come before the county to do anything because they just happen to be an investor, but they are not knowledgeable about anything that's happening.
So this would be an investor in a party,
Yeah.
or I'll be happy to look into that and send you a follow-up.
I'm just
Yeah, that's a
curious
great
because
question.
it just seems like there would be people that would make donations that, sure, they might have investments all over the place, but they're not going to know what those organizations or companies might be coming to the county for in the near future. And then I'm curious, how is this enforced in terms of the donor or the participants?
It hasn't been enforced yet, so it's all
Or how-
speculative at this point. But it's all it's a violation under the Political Reform Act, and the FPPC could, as it saw fit, issue penalties, and in theory could refer to a DA or the Attorney General for civil or criminal enforcement as well. I don't know how that's functionally going to shake out, but similar to our conversation from last month, if you have somebody making a contribution that exceeds the limit allowed by the FPPC, it's not just the candidate that receives it that has violated the act, it's the donor as well.
Yeah. So it's really incumbent upon the officer to make sure every single person knows that there is this rule before they make a donation.
I think
Yeah.
it would be a good idea.
Yeah. And if there's a way, I think, to Supervisor Cottrell's point about, something that we all would be able to use, if there's also just some layman's explanation of what this is so that we can make it really clear to people and they can understand it without having to go into the code and try to figure out, where they might fit in. I think that would be really helpful. Whatever you can do to make it easier
Absolutely.
we'd be grateful. Thank
Yeah.
you.
Supervisor Cottrell.
Thank you, Chair. I was looking a little bit more at slide 9 about what is pending, and just to muddy the waters a little bit here. So we've been talking about, if an item is placed on the agenda, it looks like under B1, there are 2 parts separated by an or, right?
Mhm.
So it can be any item once it's agendized, but that second set of clauses there talks about the officer knowing or having reason to know, and that it's reasonably foreseeable that the decision will come before the officer. So am I thinking any item that, once there is an appeal in place, even if it's months before agendizing, one can say, because of the act of someone appealing it, that it's reasonably foreseeable. So I think we'd want to be And I think this just sort of supports the recommendations you're making, being proactive and somehow publishing to the board what are items that have been appealed, even if we're, as Supervisor Gregory pointed out, months from any appeal too, given that clause. And that's helpful for board members, but also the public.
Absolutely.
Supervisor Gregory?
Thanks. I thought of one more follow-up on previous question. The scenario where you receive a donation in excess of $250 and somebody applies 2 months later. Does that conflict that runs 12 months, does it run out? Does that conflict end at 12 months from that point?
Yes. So if it's not a contribution made during the proceeding, and the say that we do get caught up in a 12+ month waiting while it's pending, then my understanding is yes, then that contribution wouldn't get rolled up under this amended code.
Thanks.
Okay, I see no further questions from the board at this time. Not that we don't have them still. I think we're just absorbing everything that you have presented our way.
It is very dense material. Yes.
Thank you for acknowledging that publicly. And as if reading our agendas isn't enough, we now have these hypotheticals to go to sleep to at night. So thank you. At this time, I'll open public comment. Public comment on item 11A. Seeing none in the boardroom, I'll go to the phone lines. Thank you. This was simply a presentation, and it seems like we will have another because we've asked for more information. So thank you. And I encourage the board, if you think of other items, especially after we all have the time to read the hypotheticals, to contact Mr. Fitzgerald. Thank you so much.
Yeah, thank you all.
Next, it's a couple of exciting moves we've got going here on the county, and I'm going to bring up our Director of Human Resources, Ms. Briseño, to walk us through item 11B, where we will be appointing Brian Bordona as our Director of Planning, Building, and Environmental Services. But I may add, we are simply removing the interim from your title. Ms. Briseño.
Good morning, Chair and Supervisors. Before you today is a recommendation to appoint Brian Bordona as the Director of Napa County Department of Planning, Building, and Environmental Services. With an impressive 24 years in public service, Mr. Bordona has been serving as the Interim Director of PBES since October of 2022. His journey within the department began in 1999, where he initially served as a planner and a supervising planner, and showcasing a profound understanding of land use, the agricultural industry, and environmental stewardship. Over the years, he's progressed through the department to hold key leadership positions, including the Deputy Planning Director, as well as the Assistant Director of the department. His recommended base salary is $230,173, with additional benefits applicable by County Policy 37C-3.
Thank you. Any questions from the board? I'll come back for comments in a bit. Seeing none, I'm going to move to public comment. Public comment on item 11B, the appointment of Brian Bordona. Seeing none in the boardroom, I'll ask if there are any commenters waiting on the line.
No one on the line.
Seeing none, I'll bring it back to the board for your decision, comments. Supervisor Gallagher.
Well, this is a fun agenda item. I just wanted to say that congratulations to Brian. We're really excited to have you as our Director of Planning, Building, and Environmental Services. I started working with you back in Planning Commission days, not that long ago, and it was wonderful to have your support and your knowledge and your experience there, and very excited about the future and working closely with you. And so congratulations, you deserve it, and we're really, really happy you're in this position.
Thank you.
Supervisor Pedroza.
Thank you, Chair. Brian, congratulations. You know, not only do you deserve it, I think you've earned it. And to be here today, to be someone that's been part of the county for so long, I think that speaks volumes about the county. But also to any employee, right, that's been so committed to the county, to see that you have these upward mobility opportunities. If you work hard, you create value, you can climb to be the director. And I think that's a story you want to tell, and you epitomize what hard work means. You're here today, but I know you spent countless days, hours beyond that 9 to 5, preparing, doing the work, and leading by example. So I just want to thank you, but also to the people that have mentored you. I think you've had a lot of good mentors. Director Morrison, not sure what the title is at this point, but people like him have really, I think, mentored you and provided you the experiences and the opportunities for this moment. You're ready for it.
Supervisor Cottrell.
Thank you, Chair. And just to add to my colleagues' comments, I have known Mr. Bordona since 2014 when I joined the Planning Commission. And just as Director Briceño said, you've served many different positions, so you really know the breadth and scope of the department, which I think is a great asset. And also a nod to the folks who've been there as your reports and supervisors along the way. And I think as a county organization, to be able to create a pipeline where folks can move through it to positions of leadership, such as this one, is wonderful. And just what Director Briceño said, your land use background, your understanding of the importance of our ag industry, and also environmental stewardship in the county, we're lucky to have you.
Supervisor Gregory.
Yeah, I'll add briefly, you're the right person for the job right now. And do appreciate how long you've been in the department, and now you're in charge. And it's a great story. I agree with that. And this comes as no surprise to the community, I don't think either. You're known to be a clear communicator with applicants and stakeholders, and you have the respect of applicants and stakeholders, and you treat everybody, whatever side they are on a project, fairly. So, good job, and I look forward to seeing you lead.
Thank you.
Brian, it truly is a pleasure to have been able to extend this offer to you on behalf of the board for your commitment to the county, to this department. But really what really sticks out the most, and I think you heard it here and it bears repeating, that the trustworthiness that you bring and you have with the community in engagement and communication and within the department, you have shined through the last few months in showing us what you are capable of as a leader, and we are pleased to be able to welcome you on board to lead this organization, to be a leader within this organization and to lead your department. So with that, I will go ahead and entertain a motion.
So moved.
Second.
I'm going to give that second to everybody. So that's going to be a motion by Supervisor Cottrell. It's second by Supervisor Gallagher, and everyone else joins in. All those in favor?
Aye.
Aye. Opposed? Motion passes unanimously. Congratulations.
Thank you.
We do not have any set matters or public hearings for special districts. We do have a public hearing now for CSA 3, our Community Service Area number 3. The Auditor Controller requests adoption of a resolution adopting the recommended budget for this district. And with us this morning, our Auditor Controller, Ms. Tracy Schultze. This is an item that was continued from July 18th, and I will reopen the public hearing.
Thank you. Good morning, Chair Ramos, members of the board. This item before you has been prepared based on recommendations by staff at the July 18th hearing with the renewal of the streets and maintenance portion of the assessment district. There are no additional changes to report, and Director Lederer is here if there are any questions.
Any questions from the board? Seeing none, I'll open public comment. This public comment on item 13A. Can you see any in the boardroom, any on the phone lines?
No one on the line.
Seeing none, I'll close public comment, and I will bring it back to the board. And our requested action is for adoption of a resolution for the recommended budget of CSA 3. Don't all speak at once.
So moved.
Second.
Motion by Supervisor Gallagher, second by Supervisor Gregory. All those in favor?
Aye.
Aye. Opposed? Motion passes unanimously. Thank you so
This
much.
now concludes the 23-24 budgets for the year.
Excellent. Thank you so much. Again, to all of our staff within the Auditor Controller's Office, within the CEO's office budget team, and now we are completed with our budget. Next, I will take up item 13B. This is a public hearing for Zone 1 rates. The Director of Public Works requests adoption of a resolution adjusting rates as shown in the resolution effective October 1, 2023. And I will now introduce Mr. Letter, our Public Works Director, to guide us through this item.
Thank you, Chair Ramos, members of the board. Steve Lederer, Public Works Director. We are here. I was hoping to keep mine as short as Tracy's. We are here today to discuss Zone 1 rates. This is an annual agenda item. Zone 1 is the area, basically the unincorporated county south of Yountville. There is a map in the staff report. So this covers garbage recycling, composting rates for that area. There is a formula which we implement each year, and the key elements of those of that formula are primarily Consumer Price Index, CPI, any changes in solid waste disposal fees, meaning this is basically the cost for our hauling company to dispose at the Devlin Road Transfer Station. In this case, that fee went up $1. This year, the cost to dump green waste, the cost to dump garbage, the cost of food waste disposal, commercial food waste disposal, and then anything we either gain or lose through recycling markets. The net of that this year, CPI was actually significant, but the contract actually has a cap on it at 5%. So that's the biggest driver this year is CPI. As I mentioned, there was a slight cost of disposal. There was actually a benefit in the recycling market. So the net is, the proposal is an increase in commercial fees of approximately 5% and no change in residential fees this year. There was a correction memo. There was one stray page in the original resolution, which I removed, so each of you should have received a resolution or a correction memo with that one page removed, but that does not in any way change the original recommendation, 5% commercial, 0% residential.
Thank you. I didn't actually say it, so I will say it. I'll open the public hearing on this. We do have a correction memo here at the dais for us, 13B, for our review. Supervisor Cottrell.
Thank you, Chair, and thank you, Director Lederer, for the report. I had a question. I'm looking at page 3 of the legislation text when you outline the six of the key factors, and we can see, for example, the increase in green waste from 47 to 49 on item 3. On item 5, it says a new food waste tip fee. So is that, there was not a food waste tip fee before? Is that what we're to understand?
No, there was not. In the past, we had this is commercial only we're talking about here. And in the past, we had a pilot program to start collecting food waste, which we've been implementing over the years. But now that SB 1383 requires all commercial and residential to compost, collect, and compost the food waste. There's now a charge for that, just a built-in charge.
So I'm imagining that will be an impact on commercial operations. Are they? But you're also saying that the total that most people will feel is a roughly 5% increase. So that's getting rolled in, and is that because of the credit piece that will kind of offset that a little bit, or how are you thinking about that?
Yeah, that's correct. We did have a good year in recycling markets.
Mm-hmm.
They're very the markets are very inconsistent. We have good years, we have bad years. This year we had a good year. next year, well, if I could predict next year, I probably wouldn't be working here because I would just invest in it. But we did benefit from a good year on the recycling markets.
Got it. And then just my final question. So there's not going to be a food waste tip fee for residences. So how will they sort of handle that food waste?
Well, residents right now have always had a green waste can. And in theory, up until a few years ago, the only thing they were allowed to put in it was green waste. They can now add their food waste to it. So there's essentially no change in cost for us to collect it because we're still simply collecting the same can. So there's no change in fee. It's just built in.
Okay, got it. And thank you for answering all my questions because I am thinking about 1383 and how we implement it. So do these commercial accounts also have a green waste bin?
Every commercial entity that generates organics is required to have one. They don't all yet. We're still going through that process. There are some number of businesses. Many businesses already had a compost can. Some didn't, either because perhaps they weren't aware of it, and when we contacted them, they started service. Some have tried to make the case that they either don't generate any organics, which is a really difficult case to make, or that they want to do something else with them. For instance, composting on site, which some can, although we're talking all organic, so we're talking meat products, and we're talking chicken bones, and we're talking the kind of things that generally really can't be composted on site. So we believe ultimately just about every commercial entity will end up with service because they're required to do so. At the end of the day, the proof will be in the pudding, because another piece, or the proof will be in the garbage can, if you will, because the other thing that 1383 requires is we actually do what are called lid flip audits. We're required to go to a certain number of residences and a certain number of businesses and actually open their cans and see what are in them. So if a business comes to us and says, we truly have no organics, when we go do the audit, when we look in their garbage can and we look in their recycling can, if there are no organics there, well, they're right, that's okay. But we think those that can do that, it will be very few and far between. So we basically expect 99.9% of businesses to end up with composting food waste cans.
Got it. Thank you. And I think this would, not to ask for a formal request, but it would be great to track this informally over year to see what kind of food waste numbers are being generated and correlated in these tip fees. Because I know Supervisor Pedroza and I in those Upper Valley waste management meetings have heard some statistics about 200 commercial accounts and 100 green waste bins or something like that. So to just track how that is being adopted would be, I think, of interest.
Yeah, we do have all that information, not only for Upper Valley, but also for Zone 1. It's one of the things that is required to be provided. I actually failed to mention Napa County Recycling and Waste Services are our franchisee that do provide these services. Greg Kelly was here earlier this morning, but he had to I guess go pick up some garbage somewhere. But Greg sends his apologies, and the company has been a very good partner in this effort.
Supervisor Gallagher.
I'm sorry, I had actually had the same question as Supervisor Cottrell about the new, quote unquote, new fee, and actually I had questions about the page that we weren't supposed to get. So I think maybe I don't have any questions. We can talk later. Thank you.
Yeah.
I see no other questions from the board. At this time, I'll open public comment. Seeing none in the boardroom, I'll turn to the phone lines. I will close, as we have no one on the phone lines, I will close public comment, and I'll bring it back to the board. Our requested action is adoption of the resolution for our new rates.
So move.
Second.
We have a motion by Supervisor Gregory, second by Supervisor Cottrell. All those in favor?
Aye.
Aye. Motion passes unanimously. Thank you so much.
You bet. Thank you.
That brings us to the conclusion of our items. Legislative items from the committee?
None?
Thank you. Committee reports or announcements?
Good.
Supervisor Gregory?
Thank you. These last few weeks were the weeks of the 2x2s. Quick updates on the Calistoga Fairgrounds 2x2 on behalf of Supervisor Cottrell and I. We met 2 weeks ago with the City of Calistoga reps. We meet again this week, and we expect the results of these conversations will be on an agenda soon here for the board to consider. The other 2x2 is the facility planning conversation with the City of Napa. We held our first meeting last week, Supervisor Gallagher and I, and we expect the results of that to show up in the staff report for August 22nd related to facilities.
Thank you. Supervisor Cottrell?
I just wanted to report a lot of communication and questions for PG&E given the rash of outages we've had in Angwin and Deer Park. And so continuing to talk about resiliency and how we can get more undergrounded and redundant lines there.
Supervisor Pedrosa?
Thank you, Chair. And just to the committee that's looking at the conversation with the city, I think it would be great if we could also include not just co-sharing spaces, but the city's also looking at, parking garages that might not be relevant, and an opportunity maybe if we were to sell corridors and the garage is no longer needed, an opportunity to sell that as a unit could be very valuable and a win-win. So I just hope that's on the table. Then I had a great tour with Mayor Sedgley. We toured Hennessy, and it was great to see what the city's doing. I think they've been an incredible partner in water storage and providing water to our residents, but I do think it's worth continuing the discussion of how do you look at water storage capacity. We're dependent on the state for water, and that may be there and may not, but to the fact that we have reservoirs in our community, I think there's a responsibility to look at how do we make sure we're trying to increase storage as much as we can. So it was a great trip, and I do want to thank the city for facilitating that.
Okay. Next, we will move on to future agenda items, and I have one of great importance that I want to ask my colleagues in joining me in for future consideration, some of which is underway, but I'll go through the list. We have had some very horrific accidents on Coombsville Road, going up towards Wild Horse Valley Road, as there is a very attractive nuisance and made up vista point by members of the community up on Wild Horse Valley Road. So there was an accident of minors that were speeding, and we are lucky that no one is dead from it, but the high rate of speed has really energized the community into really raising some of the great concerns that have existed for a number of years on Coombsville and Wild Horse Valley Road. And so for consideration of a future agenda item, one which is under consideration, which is under construction, is the creation of a berm to block off available parking on the side of this attractive nuisance on the top of Wild Horse Valley Road. But in addition, I would like to ask that staff evaluate if there are any other opportunities for creation of berms or signage on other parts close in around that area that would facilitate parking, although on private property, but if there's an opportunity for better signage or additional berms on that area. Next, which I believe is already underway, the acquisition of speed radar feedback signs that would be strategically deployed on this strip. But the most important one that it would require board action would be for us to evaluate the execution of stop signs at various intersections. When you leave the city of Napa, you're on Coombsville Road at South Terrace, there is no stop the entire way up. And this has really created a problem for, of course, it's reckless speeding. But there are great opportunities for us to evaluate that. So my request to staff would be to evaluate the potential stop signs at 4th Avenue, especially 4th Avenue in Coombs, to have engineering look at 1st Avenue in Coombsville, and then also Green Valley Road at Wild Horse Valley Road, and to do that in an expedited fashion, and to also work with ITS so that through Google Analytics we can try and drop the feedback. This is listed as one of the top 10 Vista sites in Napa County, and it is a dangerous condition. So my request is quadruple fold, but I hope that we can address this in a swift manner so that we can create a more safe environment for the residents of Coombsville. Supervisor Cottrell.
Thank you, Chair. I would like to add another, I guess I would call it safety-related item, and it does go back to PG&E. One of the things we have learned in this past week is that PG&E has worked to end its enhanced vegetation management system. They're continuing to do vegetation management, but that particular program, which was a quite wide swath of clearance around wires, they are moving toward just a broader adoption of the EPSS system, which makes sense on a lot of reasons, but I think we do need to understand what the impact is in our county. So to have the opportunity to learn more about that and also understand PG&E's undergrounding plans in the county, I think would be helpful for the board.
Thank you. Supervisor Gregory.
Thanks. I'd like to go back to the chair's suggestion and expand that a little. Pardon me.
Sure.
I have a success story from District 2. We put speed feedback signs up on the Orchard Road sharp turn. It's been incredibly successful and well received by the neighborhood. There's more, looking at Mr. Lederer. And I think we often defer road safety to CHP since they do that for us, but I do think we have a very big responsibility in this, and I've got areas in District 2, the Redwood Road wiggle, which is very dangerous and often has accidents, and that's, I think, where we could do more also. So I would like to expand your idea into a conversation around that and look to provide Public Works some budget to do this stuff elsewhere. Is that fair?
Fair. Thank you. Supervisor Cottrell.
I just wanted to let our new CEO know that Supervisor Gregory is an engineer, but I don't think that term wiggle is technical.
Thank you. Thank you. Okay. We have, looks like we've added a lot of cost in our future agenda items. Mr. CEO, this is your opportunity for a report and announcement.
Thank you, Madam Chair, members of the board. I have no report this morning. I just wanted to thank all of you for your hospitality this week. I've enjoyed my day and 4 hours so far, and I want to thank the community. People I've run into have been very polite and nice, and my son and wife and myself, we're enjoying our time here, and look forward to working with all of you and everybody here in the audience, all of our fellow staff members. Congratulations to Brian on his appointment. I'm looking forward to working with him. Thank you.
Thank you. We do not have any closed session items today, and this brings us to adjournment. The Board of Supervisors will adjourn to the regular meeting Tuesday, August 15th at 9 a.m. We are adjourned.